that's been going on in Salt Lake City, and we want to thank you for your participation and continued support of this seminar. I am the chair of the Employment, Labor, and Immigration Department of firm. And we have some great presentations today, some timely presentations regarding developments in the Americans with Disabilities Act, various hot topic issues regarding COVID-19 and vaccinations, the number of how to do proper investigations, a number of timely topics. I think will be very beneficial to you as you are managing your workforce. So again, I just wanted to quickly pop in before Kevin's presentation, say thank you for joining. Thank you for continued support, and I hope you enjoy the next 2 days of presentations. Thank you.
Hey, thanks, Sean. And I echo Sean's comments. I welcome all of you to the 33rd Annual Parsons, Behle, and Latimer Employment Law Seminar. We're thrilled to have you. We wish we could do this in person, but it's nice to have you virtually. And we look forward to next year for our 34th to do this in a ballroom where we can all connect and convene and be in person. Again, my name is Jason Kaster. I'm the Chief Business Development Officer for Parsons, Behle, and Latimer. And it's great to have great representation for today's employment law seminar. We've got people logged in from Idaho, Montana, Nevada, and Utah, which represents all of the firm's offices. So thanks again for taking time to join us virtually today. As you know, this year's seminar will take place over the course of the next 2 days from 8 a.m. to 12 p.m. Each presentation will last 55 minutes, followed by a 5-minute break between sessions. I'm excited about today's agenda and the agenda that we have prepared for you for the overall seminar. So let me touch briefly what we're going to talk about today. I'll address what we're going to touch on tomorrow, and then I'll kick today's meeting off with our first presentation. So today's session is going to include issues related to the Americans with Disabilities Act, hot topics ranging from protected classes to gig workers and more, political speech in the workplace, and lastly on today's agenda will be internal investigations. On tap for tomorrow will be the following: hot topics, session number 2, which will address marijuana in the workplace and issues related to COVID-19, including telecommuting, masks, vaccinations, and much more. Our second session will focus on Utah's non-compete statute, which is celebrating its 25th anniversary. This will be followed by a professional work visa options. And lastly, we'll conclude tomorrow's seminar with a discussion around FLSA and regular rate of pay calculations. Before I turn the time over to our first presenter, I'd like to cover just a couple of quick housekeeping items. First, today's seminar is being recorded, and you will be provided a link along with a copy of today's PowerPoint presentation to share with your colleagues and teams. Second, today's webinar is intended to be as interactive as possible, so please feel free to submit questions using the chat feature throughout our discussions today, and we will do our very best to address your questions. And finally, for the purposes of CLE and HRCI credits, here's how this is going to work. For those of you who need CLE, we will submit this on your behalf and send you a certificate by way of email. Similarly, for those of you that need HRCI credit, we will email you a certificate of completion for reporting purposes. And with that, I think it's I'm gonna stop talking and turn the time over, or introduce rather, our first presenter, who's going to address important ADA issues that have arisen from the COVID pandemic. Kevin West is a shareholder in the firm's Boise office and focuses his practice on a variety of employment law and litigation matters, with a particular emphasis on clients in the healthcare industry. Kevin, welcome. Thank you for being with us today. Thank you for taking the time to prepare this information, and I'll turn the time to you.
Okay. Thank you, Jason. I appreciate that, and good morning, everyone. I'm joining you from my office in Boise, Idaho. Good to be with you, and I'm very honored to kick off this conference for the year 2021. I just want to let you all know, when you receive the seminar materials later, you'll have some handouts that I included with my materials that I think you'll find a good reference. There's a EEOC guidance regarding the pandemic, two different EEOC documents in those materials. and then an article about mandatory vaccination. So when I chose this particular topic earlier in the year, and we do a lot of advanced preparation, I think I chose this topic in the early summer. Things were very calm then with COVID. Everything was opened up again. And I was very concerned, is this topic still going to be relevant by the time I give it in the fall of this year? Obviously, I needn't have worried. It still is a very relevant topic. Think of some of the scenarios that you've either encountered or that you likely will encounter as employers. You have an employee who is at higher risk of getting COVID or getting complications from COVID. Do you have to make an accommodation for that person because they have that susceptibility? Maybe you have an employee who claims that a disability prevents them from wearing a mask in the workplace and your workplace requires masks. Say you have an employee who, despite your policy on vaccination, claims it is unsafe for them to get a vaccination because of a medical condition or disability that they have. Perhaps you wish to implement certain testing protocols or screening protocols in your office, and once again, you meet with objections from certain people. Perhaps you have an employee who is extremely anxious and they are afraid to be in the workplace because of the fear of getting COVID. What do you do in that situation? These are only a few of the issues that really have arisen during the time that we've been in the pandemic, and most of you have probably faced at least a number of those particular issues. Another thing I've noticed are that legal standards, especially under the Americans with Disabilities Act, have evolved during the pandemic. Certain things that we never would have thought were permissible before the pandemic are suddenly so commonplace that we hardly even need to mention them. But the rules for the Americans with Disabilities Act have become somewhat elastic, as we'll talk about during the presentation. The involvement of the federal government, especially the CDC, has also had a dramatic impact. As it used to be that establishing that an employee was a direct threat in the workplace was a very high bar for employers to meet. Well, the federal government has taken employers off the hook because the EEOC and other agencies look to the CDC for guidance, and the CDC has said that COVID is a direct threat. So that burden and bar has now been met. So let's mention a few basics before we get into the meat of the presentation. People talk a lot about the ADA, but they oftentimes have actually never read the core statutory language. And you have that on screen in front of you. Let me just read it. No covered entity, and again, that would be an employer with more than 25 employees, shall discriminate against a qualified individual, important language, on the basis of disability in regard to job application procedures, hiring, advancement, discharge, compensation, training, other terms and conditions and privileges of employment. That is the core statement of the Americans with Disabilities Act. And, you know, the Americans with Disabilities Act is a very complicated and lengthy set of statutory and regulatory provisions, but when you boil it down, it really comes down to two basic duties, as you see on screen. Number one, to reasonably accommodate unless doing so would be a hardship. And then secondly, a duty to not only segregate and safeguard confidential health information, but also to only obtain it in a proper manner through certain medical inquiries or examinations. So these are the two fundamental duties, when you boil everything down, that are required by the Americans with Disabilities Act. Speaking about reasonable accommodation, I would also say that that really comes down to how you change or modify two things when you're doing that. Number one, are you going to modify the physical workplace? And number two, are you going to modify or restructure the actual job and its duties? When you think about it, when we talk of reasonable accommodation, we're almost always talking about one of those two things: modifying the workplace or modifying the job. And of course, we may be off the hook in doing any of those things if doing so would constitute an undue hardship. Everyone in HR has heard the term interactive process. It's become a commonplace in the ADA. And certainly we need to all remember that the law does not require precise accommodation. It requires reasonable accommodation. And what I mean by that is there may be three different ways of accommodating a particular situation. And the employee may be requesting option A, and it may work out best for the company to do option B or C. So do we have to do option A? No. We only have to do an option that accomplishes the purpose. So it does not necessarily have to be the accommodation specifically requested by the employee. But regardless of the option that we choose, there has to be true interaction. And whenever you read an ADA case in the courts, almost always, if you read in that decision that the employer tried in good faith to accommodate, you almost always are reading a decision that comes out favorable to the employer. Not always, but almost always. And likewise, when you read of employers who basically gave the employee a stiff arm, did not talk with them, did not engage with them in the process, when you read a decision where that was the fact pattern, almost always you're seeing an employer who has lost that case. So we say interactive process all the time, but unfortunately, it still doesn't happen in many workplaces. So the second basic obligation is having to do with gathering and safeguarding health information. And here we have a couple of important responsibilities. Number one, we are not supposed to either conduct quote unquote medical examinations or conduct disability related inquiries and unless such are consistent with business necessity. So we're allowed to determine if an employee can perform the essential functions of their job. That's considered business necessity. And we're also entitled to determine if an employee poses a direct threat to others. Those are allowed within the scope of the ADA. And the direct threat issue, as I mentioned a moment ago, has, in terms of COVID, now been established by the CDC, which has said that COVID is in fact a direct threat in the workplace, and employers no longer have to meet this high bar when it comes to that particular condition. In terms of safeguarding medical information, during the process of accommodating someone, perhaps getting an opinion from their medical provider, an employer is going to get health information. And the ADA imposes an obligation for employers to safeguard that information. I still see far too many employers who are putting employee medical information in an employee's general personnel file. And that is completely inappropriate. If you are getting health information from an employee, it must be kept in a segregated place And often that means you are having basically a second file for each of your employees, whether that's paper or electronic. But that information cannot be simply placed in the personnel file with the W-2 form and the I-9 and those other basic documents. It must be kept segregated, and it must be protected. So I used the terms a moment ago that there's restrictions on the ability to do disability-related inquiries, and on the screen you see the definition. Such an inquiry is something that is likely to elicit information about a disability. And then a medical examination is a term of art where, that's a test that's going to seek information about a person's physical or mental condition. All right, in the hiring and onboarding process, there are also some protections that we will talk about in a moment. I'm going to move past this slide for right now. So let's talk a little bit about COVID and how it is impacting our obligations under the ADA. We have so many different scenarios that can come up. I mentioned a few at the beginning of the presentation. We have issues relating to mask mandates, to vaccine mandates, to how we deal with vulnerable employees. We are also seeing issues relating to the employer sending their employees onto the job site of another company or client. And there's been discussion about what do you do when one of your clients says to you, do not send an employee to my office, one of your employees to my office or to my workplace unless they are vaccinated. How do we deal with that particular situation? We certainly cannot disclose to outsiders who in our workforce has been vaccinated. So what do we do when we get a request like that? And the suggestion I have made is if a client makes that specific request, we should give them the assurance that while we are not going to identify the vaccine status of any particular employee, that we will give them the assurance that we will only send people who have been vaccinated, and we will make that representation to them. But we certainly cannot identify to them who has not within our workforce specifically been vaccinated. That is not permissible under the ADA. And the same is true with people coming onto our work site outside of our company. We can certainly request of those clients or others who send people to our workplace that they send only people who either are wearing masks or who are vaccinated. But as to any particular person, we cannot inquire as to their individual status. So that's a few scenarios. Another interesting phenomenon we've seen is that certain employees who had conditions that never required accommodation in the past, suddenly during the pandemic are now needing accommodation. For example, an employee who has diabetes or some other condition that might render them susceptible. There may be situations there where an accommodation is needed, where in the past that was never really necessary. So thinking about those different scenarios, the EEOC and others have pointed out that during the pandemic, the ADA is really going to impact employers in three particular ways. Number one, the decision as to when you may or must perhaps exclude individuals with disabilities from the workplace. And that could be because they pose a direct threat, or perhaps there's even a direct threat to them. Secondly, we need to continue to remember that we have to limit disability-related inquiries and medical examinations, including for those who do not have a disability, but that's an overarching requirement of the law. And then secondly, that we have to make reasonable accommodations for people with disabilities. So those are really the three major ways in which the ADA is going to impact employers during the pandemic. Some things to think about. We know if an employee poses a direct threat, there are some factors that we need to look at. And those different factors in determining that are the duration of the risk. You know, are they sick now? Are they recovering? The severity of what may happen in the workplace if we allow them to be there. And again, the CDC has somewhat taken this off the table because of their conclusion in March of 2020 last year that COVID meets the direct threat standard. Once that threshold of a person posing a direct threat has been met, then it does open the door to certain inquiries that likely would not have been allowed before and likely would not have been commonly done before the pandemic. Things such as, are you experiencing symptoms of COVID-19? And we know the different lists of fever, cough, etc. You know, we would have never asked people those kind of questions before the pandemic, but now those questions are being asked all the time. Have you been in contact with someone diagnosed with COVID? That is an appropriate question. Once again, we never would have asked that before, but we do now. And it's not appropriate to ask whether their family members have been diagnosed. The EEOC makes a distinction there. They don't want the question specifically directed to family, but the question can be broadly stated in terms of contact with anyone diagnosed with COVID. We can ask employees if they've traveled to certain areas known to be hotspots in terms of transmission. We can ask an employee why they were absent from work. These are all questions, once again, that the EEOC has specifically said are appropriate and allowed. And again, just standing back and looking at the impact of the pandemic, we rarely would have asked any of these questions before, but now they are commonplace and we are allowed to do so. The EEOC has also said that because someone with COVID poses a direct threat, then certain types of screening examinations are now considered permissible. So temperature checks. When people are coming into our workplace, whether they're an employee or a third party, we can take their temperature. Would we have ever done that before the pandemic? I'd never heard of that happening, but that happens now in many workplaces. Employers can do testing, either the employer themselves or having a third party do it. And I'm talking about the swab testing, but the EEOC says we cannot do antibody testing. So the swab test is okay, the antibody test is not. And why would that be? Well, the antibody test does not tell if a person currently has COVID. It simply tells them that in the past, at some point, that person had COVID because they now have the antibodies. So that's an important distinction. The antibody testing, my understanding, is usually done with blood too, so it's a more invasive test, and that may be another reason. But as you can see, in terms of disability inquiries and medical examinations, that the rules of the ADA have become somewhat elastic, and things are now being allowed that we would not have done before. Someone could argue, well, those were always allowed before, that just wasn't a need, and that could be a valid argument, but clearly things are now being permitted by the EEOC because of the determination that COVID poses a direct threat in the workplace. All right, most of the rules we've been talking about now have related to the existing workforce. So what about hiring and onboarding? What about applicants? What standards apply to them? The traditional rules under the ADC remain generally the same. Before we extend an offer to someone, it's really not permissible to make any kind of disability inquiries or conduct any kind of medical examination. But once we have made a conditional offer of employment, an employer can screen applicants for COVID symptoms and conduct medical examinations such as temperature checks or other examinations that determine fitness for duty. In some situations, if a person has COVID at that time, we can delay the start of their job and potentially even withdraw a job offer in certain circumstances where we need someone like right now and they have COVID and so we can't hire them right now. We could actually withdraw a job offer in that particular situation. All right, let's talk about the issue of protective measures. So I don't even think it needs to go without saying that employers can require certain hygienic things like washing your hands and social distancing, certain things like that. Employers clearly can require employees to wear protective equipment, depending on the circumstances, more so perhaps in a medical setting than not. But you know, the issue of requiring masking, some people thought was controversial at the beginning of the pandemic. I don't think anyone really considers it controversial now. But the whole issue of masking has raised a host of requests for accommodations from people who claim that they are unable to wear them for physical or mental reasons. And in my experience, relatively few of those requests for accommodations really carry a lot of validity, but I'm not saying they never do, but there are certain people who have very severe clinical mental health conditions such as claustrophobia, maybe PTSD, maybe some other things where there is a true clinical reason why a mask is a problem for those people. And in those situations, accommodation needs to be made where possible, allowing them to be in an office by themselves or to be distanced in some way or to work remotely or to have some other type of protection. Those things are going to be required as potential accommodations for people with those particular conditions. So what about really what I think is kind of the issue du jour is the issue of vaccines and vaccine mandates. And of course, when this presentation was prepared, it was prior to the president's soon to be issued requirement, it appears, for employers with 100 or more employees to be mandated. But there's still many in this group who are less than 100 who are still making a decision about whether they should require vaccines or not in their particular workplace. So this is an area of significant controversy and is an ongoing area of controversy. So certain things are clear, other things not so much. But one thing is clear is that an employer can ask if an employee has received the vaccine. Okay, and I hear people say all the time, well, that's a violation of my rights, that violates HIPAA, blah, blah, blah. None of that is true. It's crystal clear. The EEOC has said it, courts have said it. Employers can ask if one of their employees has received the vaccine. Now that information must be kept confidential, obviously, but they can make that request. It's very clear that you can require an employee to show you proof that they have been vaccinated. You cannot ask an employee why they have not been vaccinated. That is not permissible, but you can ask them proof as to whether they have been. It's very clear now that incentives can be offered to employees to be vaccinated. And we've seen a variety of incentives out there being offered, all the way from small cash bonuses to reductions in premium for health insurance. We've seen those things. We've actually seen negative incentives where employees who refused to get vaccinated actually were required to pay a greater amount for their health insurance. And to my knowledge, none of those incentives have been struck down or really even seriously challenged. And then the final ultimate question is, can employers mandate? And in the few cases out there that have resolved that issue, the courts have said that they can. The only exceptions I have seen to that is where the mandate failed to include the two key exceptions for disability and for a sincerely held religious belief. If an employer's policy does not include those exemptions, then there is going to be a serious threat of a legal challenge, as we've seen in New York and some other places, based on that failure. So let's talk a little bit about those two exceptions, which, you know, the articles I see every day in the literature, those two exceptions are generating a lot of concern. It's important to make clear that those two exceptions actually arise under two different laws. The exception for a disability, you know, I cannot be vaccinated because I have a medical condition or disability, that exception arises under the ADA. However, the religious belief exemption arises under Title VII. And because the two exceptions arise under different laws, the standards are somewhat different. Most of you in this audience are very familiar with the disability exception, because we deal with that all the time. An employee tells us they're not able to do something or they need an accommodation, and most HR people have become adept at obtaining the necessary information either from the employee, from doctors, or from others. And so, you know, we're able to do that. So if we have an employee who comes to us and says, you know, I cannot be vaccinated because I have Guillain-Barré syndrome or some other condition that's documented to be a legitimate problem if a person is vaccinated. And there are not very many of those conditions, by the way, but there are some. So that can be documented by doctors or others, and that's, again, usually something that can be sorted out. The bigger problem is really the Title VII exception for the sincerely held religious belief. And that's the one that's really flooding the workplace these days. And I heard a colleague say, I think it was Sean Monson, say, you know, a lot of people are finding religion these days. And that, in fact, is true. I had a client who operates an assisted living facility in another state. And that client, the owner of the facility, called me and said, my particular state is mandating vaccines for everyone. And if I require my employees to get that, I'm going to lose every employee and I will not be able to operate. And then the kicker was, the request to me was, Mr. West, we need you to help us create religious exemptions for all of our employees. And, you know, the request was stated in such a way that I just obviously did not feel comfortable helping in that situation, because there truly was not a legitimate basis for the request. It was simply an effort to get around a mandate for in whatever way possible. So the religious exemption is very problematic. I see different approaches on this. Even from experts, I see disagreement. I see some taking the position that once a person claims a religious exemption, that all inquiries are off the table and you just have to accept it at face value. I disagree with that. I think there is a middle road where an employer certainly can make appropriate inquiries. They certainly can sit down with the employee and discuss the issue with them, and really determine whether it's an appropriate request for this exemption. And it's important to understand, political beliefs do not constitute a sincerely held religious belief. And even though in this day and age, people's political beliefs are sometimes so strongly held that they almost appear to be religious in nature, nevertheless, a political viewpoint is not a religious belief that would allow an exemption. Likewise, the mere fact that a person just has a strong personal feeling about not being vaccinated, again, that does not equate to a religious belief. The mere fact that someone believes strongly in personal freedom or autonomy, once again, is not necessarily a religious belief. And certain people have pointed out that there are very few organized religions who have taken the position that getting vaccinated is contrary to their religious tenets. So it's also important to point out at the same time that it is not required that you belong to a religion that has taken that position. You can still be somewhat of an outlier within your own religious community in taking that position. So the long and short of this all is that the whole religious thing is very subjective, but it's also very clear that many people are asserting that exemption improperly, and relatively few of these requests for exemptions, in my particular point of view, appear to have any legal validity. All right, moving on from that controversial topic. Well, maybe a final comment on that topic. If you are considering a vaccine mandate in your workplace, as we've already said, it's clear that that is permissible if it's adopted properly. But whether you legally can and whether you should as a practical matter are two different things. And many employers have come to the realization that even though they can do it legally, it would create issues for them to do it, and they've declined to do it. But if you're thinking of doing it, you ought to look at the factors on the screen here. And number one, look at the risk assessment. There are certain companies, in fact, quite a number today, who all of their employees are working remotely. If that is the case, what would be the risk that would require you to mandate a vaccine for everyone? If your employees are all working remotely and it appears in the near future that's going to continue. So that's one factor. What would be the parameters of your vaccination policy? Would it apply to everyone, even those working remotely? Would it apply to people who have already had COVID? These are issues you have to think about. How do you communicate it to people? How will you handle the documentation generated by this is a thing to consider. And then, of course, the whole thorny issue of the exemptions that we were just speaking about a moment ago. So it's not as simple as walking into the conference room one morning and saying, hey, we're going to require everyone to be vaccinated. It's a much more complex issue that ought to be thought out carefully, with written policies prepared, with competent employment counsel in doing so. All right.
Hey, Kevin, we just lost your audio and video. Your video is back up.
Okay.
Okay, I can hear you just fine now.
Okay. Sorry about that technical problem. Are you okay now, Jason?
Yep.
Okay. Couple things to recognize in terms of what actually does and does not trigger the ADA. So certainly if an employee has an accommodation issue relating to COVID, they can make a request when it relates to their own particular condition, but they cannot raise COVID as a problem because a person in their household, a family member, or others may be susceptible or vulnerable to COVID. So if an employee comes in and says, hey, I've got to be segregated, or I've got to work from home or whatever because I have a family member who is vulnerable, we may want to do that as a matter of just, common humanity, but does the ADA require that? No, it would not. We also need to recognize that a person's mere anxiety about or fear of exposure or of contracting COVID does not constitute an impairment that requires you to accommodate them. Now, in saying that, I recognize if someone actually has a clinical level of anxiety diagnosed by a provider, and it actually raises to that level, then there may be in that situation an obligation to accommodate. But just a generalized concern is not going to be sufficient to trigger a duty to accommodate. So you have to look at all the circumstances involved in particular requests to accommodate in determining whether you actually need to engage in the interactive process with people. There's a phenomenon that's come into the literature during the pandemic, and there's this term long COVID, which relates to people who have had COVID and experience persisting symptoms, problems, and conditions as a result of that. And there are well-documented situations in which people for months or even throughout the pandemic continue to experience problems with the fallout from the condition. And the Department of Health and the Department of Justice have issued memos stating that long COVID can be considered a disability under the ADA. And it could be either a physical or mental impairment. And we need to make clear, just having COVID itself and recovering from it afterwards with relatively no fallout, that's not going to be a disability. But the documented evidence of the long COVID where these symptoms persist has been determined by these federal agencies to be a physical or mental impairment that can be a disability. There's, again, a precious little case law yet on COVID and engaging in the interactive process and doing reasonable accommodation. We almost have to look at antecedent cases. And, there's this one here involving asthma. And in this particular situation, the employee asked to work from home, and the employer, of course, refused to engage, and the employer, of course, lost this particular case. If you just change the word asthma to something else that was COVID related, it would probably be the same outcome. So this case may be applied by analogy, but we have relatively few cases really addressing COVID thus far. So just some things to ask if you have an employee come to you with a COVID-related condition. These are questions we would ask really of any potential disability situation, how the disability affects you, how the accommodation can help you, whether some other accommodation might help you. These are basic questions that we would ask not only with COVID, but with any other particular situation. The EEOC has made the point that in certain circumstances, and this can happen in the healthcare environment in particular, that there may be times when, because of the urgency of a particular situation, the employer may be excused, at least for the time being, from engaging in the interactive process because of perhaps a large number of employees in the workplace having an issue. There may be circumstances where the duty to accommodate immediately can be foregone. There may be situations because of supply chain issues where protective equipment or other types of accommodation are no longer possible, at least in the short term. So the EEOC certainly has recognized that there may be exceptions where accommodation is not required.
Hey, Kevin, can I interject with one quick question from the audience related to this particular
Sure.
area?
Yes.
The question is, if an employee shows up with a new disability, COVID-related or otherwise, is the employer allowed to ask for proof?
Yes. Yes, that's true throughout the ADA. If an employee comes in, they say they've got a condition and they need accommodation. Now, those things have to happen before you start making the inquiries. But if that's the scenario, the employer is certainly entitled to obtain either a medical record or an opinion or a note from the healthcare provider, not only to understand what the condition is, but also to understand what accommodations are needed and to understand whether the employee poses a direct threat either to other workers or to themselves. So that is very, very permissible. Okay, any follow-up to that question, Jason?
Thank you very much.
Okay, I have just a couple minutes and I'm going to go down and mention just quickly breeze through some Q&A, and you'll have these on the slides when you get them later, but these Q&A have come directly from EEOC guidance statements. So question, can employers ask everyone physically entering the workplace if they have been diagnosed or tested with COVID? And of course, as we've already said, the answer is yes to that particular question. Can we single out only one employee and ask them if they in particular have had COVID? And the answer is no, we're not supposed to do these inquiries in a discriminatory way and single out. If we're going to ask the question, we should ask them generally of all people, unless there is a particular circumstance that would lead us to believe that a particular person is perhaps symptomatic or has some other problem. Can an employer ask an employee who is coming into the workplace whether they have family members who have COVID? And as we mentioned before, that is not considered appropriate to single out family, but we can simply ask generally if they've been in contact with anyone diagnosed with COVID. Can we ask employees who are not physically present in the workplace to take a COVID test? And the EEOC has said no, if someone is not coming into the workplace either now or in the reasonably near future, then it's not appropriate to ask for that to happen. If an employee has COVID, then fully recovers, do they have a disability under the ADA? The answer would be generally no, unless they have the long COVID situation that we talked about earlier. If they have COVID and then recover with persistent symptoms, do they have a disability? Well, that's the long COVID situation, and they may or may not have that situation. How would you accommodate an employee due to a pre-existing disability who is at higher risk, and in particular where that employee's job can only be done in the workplace. So these are some possible accommodations, distancing, barriers, job restructuring temporarily, modifying their work schedule. It's so fact specific that it really depends on the particular circumstance. What can an employee request? Well, this is employer, that's a typo. What may an employer request for an employee seeking reasonable accommodation? We can ask questions. We can certainly get medical opinions, doctor's note. All of those things are permissible, as we mentioned earlier. If the employer receives a reasonable accommodation, that should be if an employee receives a reasonable accommodation in the workplace, but all employees are currently teleworking, is the employer required to provide the same accommodations to all employees who are teleworking? And the answer, it depends. Sometimes an accommodation that may be needed in the physical workplace is not necessarily needed in the confinement of someone's home, and vice versa. Certain people who may not have needed something in the physical workplace may actually need an accommodation in their home in terms of certain types of equipment. So we should be aware that teleworking or remote working does in and of itself raise certain issues. And then last question, if telework was implemented for all employees to slow the spread of COVID, is an employer required to grant an accommodation request when employees then later return to the workplace? And the answer is no, they're not required to, but there may be certain situations where we would consider and look at that, as you can see on the screen. The whole issue of teleworking as an accommodation has probably become much more accepted today, obviously, than it was in the past. Many employers simply would never have considered allowing remote working during the pandemic. And I think those attitudes have changed drastically. So Jason, do you have any questions in my remaining few minutes here?
Yeah, thank you, Kevin. Great presentation. So a question related to Montana law. This has been submitted twice from our audience in a very similar way. But the question is this: how does the Montana state law making vaccination status a protected class change any of this? And should they follow federal guidance over state?
Okay. I hate to punt on a question, but I'm not a Montana lawyer. I have heard of, obviously everyone's heard of the fact that Montana has a anti-vaccination mandate law, but read me the question once more, Jason, and let me think about it again.
How does the Montana state law making vaccination status a protected class change any of this? And Kevin, if you don't feel comfortable answering this, Liz Mellum follows you, and we can have Liz address this right at the top of the hour.
Yeah, and I'll let Liz do that. I would just say though that it really would not change any of the principles I talked about, because the ADA never mandated vaccines. The government agencies have simply said that mandates are permissible by employers. And so the fact that a particular state has said you can't do that in our state raises a whole host of issues in terms of conflict with federal law and other things. But I don't think it would change really very much of what I've said today. But Liz can certainly weigh in on that.
Okay, great. Thank you very much. This question from the audience is rather narrow, but I'll raise it with you in the remaining minute we've got left, Kevin. If an employee shows proof they have Guillain-Barré syndrome, can an employer require them to wear additional PPE or have additional COVID testing?
Yes, good question. So Guillain-Barré syndrome, to my understanding, is a legitimate medical condition that makes having a vaccination a threat or a danger to a person. So if we have an employee like that who cannot get vaccinated for a legitimate reason, certainly we could take other steps to protect our workplace from that person infecting others. And that could be a number of things. It could be masking, it could be physical distancing, it could be barriers, it could be requiring that they be tested on a regular basis. It could be temperature checking when they come into the workplace. It could be any or all of those things.
Okay, Kevin, thank you very much. We are out of time, but we appreciate all the information that you prepared. Our next presentation will start in just a couple of minutes at the top of the hour, and we'll circle back to the Montana question. Kevin, thanks again for being with us.
Thank you.